Next up on TWiL, join me, Denise Howell, Wendy Seltzer, David O'Brien, and Evan Brown to talk about the state of the DMCA. What's going on with that law anyway? Meanwhile, everyone's watching everyone. What can you do about it? All this and more next on TWiL.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 74, Nosferatu Cookies. Hello and welcome to This Week in Law, episode 74. I'm Denise Howell and I'm here with Wendy Seltzer, who I've been hoping to get on the show for a very long time. So welcome, Wendy. It's great to have you with us. Wendy, you can find at seltzer.org. And where is your blog, Wendy?
Well, I blog at Legal Tags, which is wendy.seltzer.org/blog. I'm also joining the Freedom to Tinker crew in Princeton at the Center for Information Technology Policy. So you'll be able to find me at freedomtotinker.com. And finally, we do some weather reporting on chillingeffects.org.
Great. I mean, Wendy, if you're not familiar with her work, has been around the technology law arena for years and years, formerly with EFF, fellow with the Berkman Center, fellow with the Silicon Flatirons at the moment in Boulder, Colorado, and just a really wonderful thinker and analyst of these difficult areas of the law. So we're thrilled to have you with us, Wendy. Thanks for joining us.
Thanks, Denise. It's really thrilling to be with you.
Great. Also with us this week is Evan Brown from Hinshaw and Culbertson in Chicago and InternetCases.com. Hi, Evan. Welcome back.
Hello. It's great to be back. Thanks for having me.
Great to have you back. And also with us for a return visit is David O'Brien from technicallylegal.org and Boston, Massachusetts. Hi, David.
How are you doing?
Doing great. Thanks for coming back on the show.
Glad to be here.
So I thought with Wendy on the show, I would take the opportunity, especially in the wake of some recent developments in the area, to do kind of a state of the DMCA and take stock of where we are with that body of law right now in the wake of the summary judgment in favor of Google and against Viacom and the appeal that's just been filed in that case. And also in the wake of the recent DMCA exemptions and the tweak that Google has made to extend the length of clips that people may upload from 10 minutes to 15 minutes if you have just a regular YouTube account. And I thought it would be interesting against the backdrop of all of that to sort of assess where we are with the DMCA. Wendy, what do you think is going on right now and what conclusions can we draw?
Well, we're about a decade plus into the digital millennium, as the Digital Millennium Copyright Act would have us believe. And so we've got a few different pieces of that law at issue here. We got the notice and takedown and safe harbor provisions that have been tested in the Google versus Viacom and other litigations that permit, encourage users, copyright claimants to send copyright takedowns to internet service providers and hosts and give internet service providers a safe harbor from copyright liability for their users' activity if they expeditiously remove the material that's claimed to be infringing. So we've got a mixed bag around that piece of the law, and I'll get into that in a bit more detail in a moment. Then an entirely separate section of the DMCA, Section 1201, sets up the anti-circumvention provisions protecting technological protections on copyrighted works, and that's where the Copyright Office recently issued its triennial rulemaking a bit later than the 3-year anniversary of the last one, giving some exemptions from the prohibition on circumventing access controls. So on the safe harbor front, over at Chilling Effects, we catalog of what the safe harbor often brings in copyright complaints to internet service providers and web hosts. And there we get between 300 and 400 complaints a week submitted by Google alone that they've received from people claiming that things in the blog and search violate their copyright, asking Google as provider of search services, information location tools, or host of blog posts to remove infringing material.
So let me stop you there for a second. Is Google posting every DMCA notice it receives on Chilling Effects?
Google is sending over to Chilling Effects all of the complaints it receives about the search and blogger materials. Not about YouTube, but removal of links from the search and removal of posts or blogs from the blogger service. And that's now between 300 and 400 a week.
Wow. And why do you think that they are playing it closer to the vest as far as YouTube goes? Why not just have transparency on that front across the board?
Well, I obviously can't speak for Google, and they have different policies and procedures in place around each of their products. YouTube has a lot more ways to get material taken down than just the formal DMCA complaint. They have the content identification procedures, the automated content filtering, fingerprinting, and matching. They have various user flags, and then they have the DMCA notice, a formal notice of claimed infringement and takedown. And there are some sites, notably YouTube, youtube.mit.edu is a site that catalogs some of the takedowns that they've noticed on Google's YouTube service, and gives some indication of the kinds of complaints there.
Wow, so that's a big job they've undertaken. They're trying to see, oh, we noticed that this video was there once and now is not there anymore?
That's right. They have to scan videos or lists of popular videos and watch for changes in the status in order to notice what's happening there, because Google isn't giving notifications.
Can you describe the interplay, and here's the reason I brought up the 10 to 15 minute extension on upload lengths, the interplay between the Content ID system and the DMCA process that YouTube undergoes every minute of every day. Content ID is flagging things on the front end, I would take it, and sometimes probably makes mistakes about what should or should not be on the site. Am I right in assuming that?
Yes, and so there, as you said, there are at least two separate processes. They have gotten a fingerprint library based on submissions from copyright claimants that they use to match against videos either before they're posted or shortly after they're posted to see whether this automated match sees similarity between a copyright claimed work and a submitted video. And there can be plenty of reasons for errors in that system. It can match on a clip that would be short enough to be fair use, a clip that's used in a transformative manner, so would count as fair use, a clip that's used with authorization from the copyright holder, and so is not infringing, or just a mistake by the technology. And so Google tells people that they can challenge these matches by the content filter, respond to that. It's not a a formal DMCA notice when there is a match, and it's not a formal DMCA takedown when there's a response to that match. Then I believe the copyright holder gets notified if somebody responds and says, despite the content filter match, we want our material to go online. And then it's up to the copyright claimant to determine whether to file a formal DMCA notice, at which point Google's policy tends to be expeditious removal of the material that's claimed to be infringing. And then finally, the user whose material was removed can file a counter notification and get the material put back online.
Right. So, David, what do you think about where we are in the wake of the Viacom summary judgment decision? And Google seems pretty comfortable with its content ID system and has cited it as the reason for extending the limit on uploads. Says that, we think it's very successful and other ongoing efforts are too. What's your take on that?
Well, certainly we just saw a rather decisive win in the Viacom decision. And it looks like all the efforts that Google has set forth in policing YouTube, if you want to call it policing with their content ID system, it's largely been successful. And the courts have recognized that in dicta in a lot of these opinions when claimants come forward to try to challenge the DMCA safe harbors, and they continue to win on most fronts. So in terms of the DMCA seems to be pretty strong these days in terms of Section 512 safe harbor. But, there's other portions of the DMCA which still have a lot of questions to them. In particular, the 1201 anti-circumvention provisions are there hasn't been a lot of clarity in terms of court decisions and interpretations of exactly what the statutory language means. And there's been a number of court decisions which really exemplify the confusion that a lot of people have about what exactly it is that the anti-circumvention provisions do.
Evan, what are your current thoughts on the DMCA and whether any of this recent developmental stuff has had much impact?
Well, I guess I'm on the wrong show because every time I anticipate we're going to be talking about the DMCA, I get all excited because I think we're going to be talking about vessel hull protection. I've brought that up on here before. So if we're going to have to talk about the safe harbor and the anti-circumvention provisions, so be it. We can do that. I really don't lose a whole lot of sleep over the DMCA or any perceived problems that people see in either of the notice and takedown provisions or the anti-circumvention provisions. The enormity of the project, or the enormity of the task of policing the web, the internet, for infringing content is just extremely large. It's extremely grand, and the DMCA seems to be doing a pretty good job at that. And I'm happy to see that YouTube, Google was successful in this because the model is legitimate enough to at least be there until we can think of something else. And from my perspective of representing clients, both who are service providers, who are subject, who are, placed in the position of having an obligation when they receive a takedown notice, and also representing creative people, and also representing content owners in the first place. I think in 99.9% of the transactions that involve the notice and takedown provision, sending a takedown notice and removing that content or disabling access to it, it serves everybody's purpose pretty well. So I'm optimistic, and I'm satisfied with the way things are right now with the status quo and all of this.
All right. Wendy, you had a fun run-in with the DMCA, or a case study on it, if you will, when you posted some bits of an NFL game. Do you want to remind us what happened there and how it came out ultimately?
Sure. This was a few years ago during the Super Bowl when I noticed the copyright infringement warning was particularly prominent in the middle of the football game, and seemed to overstate the copyright law by saying you may not reproduce, disseminate, or even it seemed to suggest discuss the game afterwards without infringing the copyright that the NFL had. So I clipped that segment, the copyright warning and a kickoff, beginning of a kickoff following, out of my Myth TV's recording of the game, and I posted it to YouTube to use as an example in my copyright class. And some NFL bot found that and sent a takedown demand. YouTube responded by removing the video, and I counter-notified, all the while having great fun with this as an example of the places where the DMCA doesn't always work quite as Evan suggested, of catching only the infringement, because I firmly believe that the posting of that copyright warning in a blog post commenting on it was in a fair use of any copyrighted material there.
Right. So how did it all end? I mean, you get kind of lost in the notice and takedown procedure, the counter notification, the counter notification. Did it simply end with the NFL deciding not to sue you?
Well, it went through a couple of rounds. So I counter notified YouTube, reposted the video, and then another bot came across the video and took it down again. And at this point, I was considering, the question was, is this now a knowing material misrepresentation of infringement? Because the DMCA does have a provision, 512F, that permits anyone who's harmed by it to sue for knowing material misrepresentation. And I considered whether to sue for the harm that had been caused by having my little video offline.
Right.
But
you
ultimately
can get
decided
damages and attorney's fees under that provision, which EFF has gotten for other people.
That's right. And I was part of the EFF team at the time we litigated Online Policy Group versus Diebold, which was the first one of the first cases to use that provision and the first one to get the attorney's fees settlement after Diebold heard the judge's ruling that this was clearly a fair use, posting some Diebold memos regarding the security of their voting machines.
Right.
So in the NFL case, at the end of the day, I sent another counter notification, and the video has stayed online since, but became a great subject for discussion around where does the DMCA work right and where does it cause too much removal, especially against people who might not have known all of the steps in the DMCA dance to get their material put back online.
Right. You shouldn't have to be a Berkman Fellow to be able to get your non-infringing video to actually persist on an online hosting service. So, well, good for you, and we're glad it's still there, and thanks for the update on that. I sort of lost track between all the it's there, it's not there. So that's good to know that it actually stayed. Wendy, you also, before we move on from the DMCA topic, you did a lengthy post on the jailbreaking exemption. Do you want to just give us a 2-minute summary of your takeaway from that? We've talked about it a lot on the show, basically leaving it at, hooray that people can jailbreak their iPhones. Unfortunate that it may be impossible for them to do so and illegal for anybody else to make an app that does it, and certainly to sell an app that does it. Any more takeaways that we should know from the exemption process?
Well, I think that great that EFF brought this exemption demand to the Copyright Office, and that the Copyright Office recognized that control of what applications you could run on your phone wasn't among the things that copyright should protect, and copyright, through the mechanism of these technical protection measures, shouldn't forbid you from moving your phone to a different carrier, installing applications on it. As you said, these exemptions are limited in scope in that they only exempt the act of circumvention and not the provision of circumvention tools. happily, there still seem to be plenty of people providing the circumvention tools and jailbreak instructions so that people can actually make use of this exemption without having to become computer programmers themselves. And I think it properly limits the scope of copyright, that Apple may have done lots of innovative and creative things in designing its iPhone operating system and its iPhone. Once it's sold that to a user, the user should be able to use that phone to build on top of it, to buy or build applications for it without infringing the copyright holder's rights.
Right. David, any thoughts about the DMCA before we move on to other things that don't also involve hull maintenance provisions?
Well, another thing came to my mind actually when Wendy was speaking earlier about the 512 safe harbor, and it seems to be that a lot of the content companies out there these days have used automated means for trying to flag content and then automating some sort of process whereby they send the initial takedown notices. And what's essentially happened here is that they've removed the human from the process, and because of that, if it's a bot that's going around that's doing this, you lose the human ability to reason through something. Should I send a takedown notice or should I not send a takedown notice? Is this an instance of fair use or is it not? You lose that when it's just a piece of software because it's just trying to flag based on fingerprints when it comes down to it. So that's an interesting quirk that seems to have happened in the last 10 years also. In terms of the 1201 anti-circumvention stuff, there's been a lot of commentary on this, so I'm not going to speak at length about it, but as a practical matter, I thought it was a little bit moot that these exemptions were finally issued with regard to jailbreaking, mostly because, a practical matter in terms of iPhone owners, just because I never really thought that Apple would pursue any kind of litigation against users individually for jailbreaking their iPhones. It just makes for bad PR in the end of the day. But at the same time, I think that hopefully the exemptions raise awareness to some of the issues that are still lingering with the statutory language of 1201, and hopefully, this causes people to go out and write to representatives and seek for further clarification in the language itself.
Right. Evan, any final DMCA notes?
Just one quick point, kind of spurred by something that Wendy said in this blog post that we were talking about earlier about the DMCA, the anti-circumvention exceptions. I really like how poignantly and how eloquently you say that copyright protects individual works against unauthorized copying. This is the part I especially like. It should not be an instrument of platform maintenance. So there really is an interesting position that the Library of Congress has put in here in terms of dealing with this as a copyright issue. And that's exemplified by what the NTIA, what is that, the National Telecommunications and Information Agency, right? Is that what it is? Administration. Said about what the appropriate role of the Copyright Office and the Librarian of Congress should be in all of this. They were saying, defer to the Department of Justice or Congress itself to resolve this issue as to how to manage a platform like this. And so it's interesting that we're put in a position where the Copyright Office is almost entrusted with a great amount of faith to do the right thing and keep its hands off of this type of platform administration or platform maintenance, as you characterize it, Wendy. So it's just a very interesting interplay between the different agencies and the different powers and different interests in the rulemaking process, how this all plays out. I found that interesting.
Yep, it Thanks. Sure is. And Wendy's post on this is excellent, folks. It's in our show notes, which you can check out at delicious.com/thisweekinlaw/74. Pointers to all our stories there for this show. And some of the stories I wanted to get to today have to do with you're being watched and listened to in various formats. Let's start with the government. There was a decision about secret GPS tracking by police, which a court has found not to be okay, which is kind of interesting against the backdrop of another story that we had, I think the last show or the one before that, about government organizations using Google Earth and satellite technology in another forum to be able to sniff out where somebody has an unpermitted pool or a bit of construction on their home and go after the fees that would be owed for that. So, I mean, they're a little bit different situations, but I think it points out that there is some tension and uncomfortableness around how we're being watched and where and what can be done with that data. Covertly tracking a suspect's car using a GPS device for an extended period of time without a warrant is apparently not okay, but going to the publicly available Google Earth database apparently is. And that's somewhat in line with the law that we've seen develop over the years with aerial surveillance and things like that. So I wanted to toss this issue out to you all and get your thoughts on tracking and surveilling by the government. David, what do you think?
Well, I think one thing that technology has enabled law enforcement agencies to do is to track people much more comprehensively than they used to be able to. And certainly we see that when we talk about GPS tracking or tracking that's supported by some sort of satellite coverage that can watch somebody go from point to point in their car and at least with some measure of precision, determine what exactly it is that they might be up to. When you cross-reference that with some sort of a map that has maybe local businesses around or names of owners of houses in residential areas. Certainly the court's opinion was a good one, I think, because, there shouldn't be the ability to have some way of comprehensively tracking somebody without at least a warrant. And what the court really focused on was the difference between tracking somebody for a day or a few hours versus tracking somebody for a full month or 30 days and seeing exactly what the person is up to. And there's something that feels inherently like an invasion of privacy if somebody is tracking your every move in your car. And I guess it was refreshing to see that the court seemed to choose the right path. But in addition, courts seem to have a problem adapting the law to new forms of technology sometimes. But I guess it was a good decision overall, though.
And maybe people have a problem thinking about technology in different contexts, specifically with this Google Earth issue, because I think when we're all, geolocating ourselves and navigating around with our mapping software, we're really happy to have this resource. But when the government's knocking on our door with a satellite photo that they didn't take but have ready access to and asking for money, then maybe the context and our feelings about it are different. Evan, do you think people should have to get warrants to look in your backyard with a satellite?
That's a great question. And, one thing that I wanted to point out, and I guess that can kind of frame an answer to the question that you've just asked there, is that it looks like there's a split in the circuits now on this question of GPS tracking. Mm-hmm. We've got, where was that, the Fifth Circuit or the Third Circuit? Where was that? That just came down with this decision that's in our show notes for today. I know it's somewhere other than the Seventh Circuit where I am. Mm-hmm. There's a case from the Seventh Circuit called Garcia from 2007 where Judge Posner held that it was not an unreasonable search for their to put a GPS device on a car like this. And he makes a very important observation toward the end of the case that draws a distinction between what actually happened in that case and some sort of panopticon of government surveillance that we could envision someday. And this is where we can kind of get this into answering the question that you ask, should it be legal for somebody or for the government to be using the, satellite technology or something like that to look into the backyard and see into the curtilage, to use, the Fourth Amendment nomenclature on all this? It becomes much more problematic when the technology permits that. And we've seen analysis of this question in situations. There's a case called Kilo that dealt with the infrared sensing of a marijuana growing operation. So much seems to be factually dependent on what's available for that surveillance. And it's almost nothing more than just it gets to a point where such surveillance can be so omniscient that it just gets too creepy for it to be not beyond the pale of Fourth Amendment sensibilities. So it's a question that's got to be dynamic, and we've got to remain flexible in our minds, at least when we're applying the Fourth Amendment to these types of open surveillance questions. Something we've got to be vigilant in monitoring.
Mm-hmm. Wendy, do you think that we're doing enough to have the Fourth Amendment adjust to the technologies that are out there?
I think we're still working our way through it, clearly, and different circuits are giving different answers on these questions of GPS monitoring, the questions of cell phone location tracking. They don't even need to put a GPS device into your car when most of us are walking around with handheld GPSs, even into more personal situations than we drive our cars, in all of our cell phones with very detailed information that can be gotten from the phone companies. And so I think we need to do a lot of work as public interest advocates and members of the public in understanding what these technologies can convey about us, how they impact our privacy, and then to take back our reasonable expectations of privacy, which is what the Fourth Amendment bases its determination whether the government needs a warrant or not upon. So at times we need to say, even though it is physically possible to track us using some of these new technologies, we demand a right to privacy because it would simply be too intrusive on freedom of association, freedom of personal relations, freedom of speech, important autonomy interests that the government should also be concerned with. It would be too intrusive on those for the government to be able to, without a warrant at any time, track these activities. So we should at least require that that law enforcement justify to a neutral magistrate that they need information that some of these invasive technologies can provide before they get it. On the Google Earth surveillance, I think we have a different situation because the technology is showing to all of us the ways that it can be used. Most of us don't see the trail that our cell phones leave, but most of us Googled our own houses or apartments to find out what that looks like from the Google Earth.
Mine looks
maps.
like I need to call the gardeners. Things are getting overgrown.
So it's at least giving us some feedback about what the technology is capable of, and giving us some warning that others might be using it for purposes less savory than our own. And then there too, if that doesn't end the inquiry, we might still decide that it was too intrusive for government to have access to these technologies, even if they are widely distributed. But we would tend then to do that by statute rather than through the Fourth Amendment.
Okay, well, it gets even a little bit more complicated, I think. We have some huge precedent in what the government can do and lots of analysis about when they are intruding too much into our personal zones of privacy. But it's a little bit more complicated when we think about companies and each other, which the government and the Fourth Amendment really have very little to do with. Another case, by the way, Evan, the case you were referring to before was out of the D.C. Circuit. This is a case out of the Second Circuit Court of Appeals that has just come down that found that secretly recording and with an iPhone, specifically an iPhone, a telephone conversation was not a violation of the Wiretap Act if done for legitimate purposes. Now, here in California, I think it would be a violation of our state law, and I think there are other states that follow that, but they're considering here only the federal Wiretap Act and saying, you know, if you're not going to use this to extort somebody, I suppose, or some other illegal purpose, but simply to keep a record or gather evidence, perhaps, some other legal sort of purpose, then it's okay to tell someone that you're not recording their conversation. Evan, do you have any thoughts on this one?
It seems to be pretty, limited to kind of a very specific factual scenario here when one is a party to the communications. This wouldn't apply to, if you're being surreptitious in dealing with somebody else's communications, if you're actually, breaking into an email server and intercepting messages as they come in, or eavesdropping when you don't know there. So I think that's one important caveat for this. And otherwise, there doesn't seem to be too much surprising in the decision to me. It seems to track the language of the statute very clearly. There is some interesting discussion as to and when I say it's interesting discussion, I don't mean to say that it's controversial. Interesting discussion as to whether, in this case, the guy who was using his iPhone to record the conversation was actually a participant in the conversation based on whether or not he was invited to the conversation. So the court held that you don't have to be invited to a conversation to be a participant in it. You can still fall into this exception for the violation of the Wiretap Act, even if you are, I guess, one who lacks the social grace to know when to not intervene in a conversation that you're not invited to. So interesting little case here. There's something that can be taken of it, but we've got to be mindful that it's limited to a pretty narrow set of facts here for the recording. And plus, it's not limited just to iPhones. That's right. Probably the reason that we got to our attention here, because it happened to be an iPhone used here, and the folks who first blogged about it, was it on Wired? Was it on Threat Level?
Yep.
They probably
David
wouldn't have written about it either if it was an iRiver. Remember those way back in the day?
Yes.
So.
Yes. David, what do you think about this? And it's fairly interesting too that they were not recording a telephone conversation at the time. They were recording a kitchen conversation, as Evan alluded to. And that was found to be just fine, basically just using the phone as a tape recorder. But as I read this, I think it would apply to telephone conversations happening on the device as well. So what are your thoughts?
Right. I didn't think that this was an especially interesting case in terms of the Wiretap Act itself. But as you pointed out, Evan, or actually you too, Denise, that a lot of states actually have much different laws. I think there might be 10 or 13 states now that require the consent of both parties, even if they're participants in the conversation, in order to record them. I know here in Massachusetts, we have a very particular law that says you cannot record the conversation secretly or covertly without the prior consent before the conversation with the other party. And that's come up a couple of times. I think we might have even discussed the last time I was on the show. I think there was an instance.
We talked about it in the context of the police, right?
Yes.
Right.
Them
they were recording the police.
Mm-hmm. And the interestingly there, the main difference is if you had made the fact that you were making a recording more obvious, you probably would have gotten around the secrecy language, and it probably would have been otherwise permissible under the law. Although, let's see, in terms of this, there isn't too much here that's interesting in terms of the Wiretap Act itself. It seemed to comply, like you said, Evan, exactly with the statute. What the main issues seem to focus on some technicalities in the statute, which require. They said that a recording would be illegal if it had been done in order to commit some other type of crime or tort. And I thought the analysis about a claim made for intrusion on seclusion, a separate privacy claim that was also made in the suit, whether or not that could suffice. But of course, the legal logic there ended on the fact that intrusion on seclusion, the act of intruding, is exactly the act of making the recording. So the court found that it would not be sufficient in order to satisfy the federal Wiretap Act. And also in Connecticut, let's see, I think that if it's a telephone conversation, I think you might need to have both parties consent. But otherwise, if you're talking about conversations outside of the phone, kitchen conversations, if you will, you don't need the consent of both parties. So interesting things going on there. And also interesting they were using an iPhone, I guess, too, right?
Right. And you raised an interesting point there, and I actually thought about this but didn't mention it in my comments earlier about this notion of a separate and independent tort from the actual eavesdropping or recording of this, and the court found that the intrusion was essentially coterminous with the violation of the act, and so couldn't give rise to the independent thing. But we wouldn't really have to strain our brains too hard to think of a factual situation where the defendant wouldn't have to do a whole lot more, but it would indeed be a separate and independent tort, like perhaps a tort, and this is, of course, would vary on from state to state, but like publication of private facts. If it was a private conversation and the person was saying embarrassing things that they didn't know were going to be made public, that seems like independent, something there that's not in the mere act of intrusion, because it's the subsequent publication. If you were going to make a recording and then do some editing, run it through Audacity or GarageBand or whatever, and do some recording and make it sound defamatory, that's something that would seem like it could give rise to that. So it's interesting to ponder for a moment, to think how easy it might be to get around the restriction that we kind of read out of, or get around the contours of the exception that we see from this case.
Wendy, do you think the courts are doing a good job in grappling with the fact that we all have devices on us that can at any time be flicked on to record either via audio or video, whatever's going around us?
Well, I think the courts are working on it. I worry even more about the huge number of cases that never get before a court and are just between friends on Facebook, posting photographs of one another, posting surreptitiously taken photographs from a party, or things that they might regret afterwards, things that will never reach the courtrooms, but at this period of thinking our way through the technology, we're going to encounter a lot of uncomfortable situations there. And so get even into Facebook's recently announced Places feature, where you can check yourself into a location or check your friends into a location. And until everyone works their way through what that looks like and what can be done with that information and what can be pieced together about their behavior based on those individually disclosed facts, I think we're going to have a lot of confusion and some unhappiness around what's made public to what contexts by this technology. And so much of it is sort of below the level of courtroom dramas, but I think very important for us to figure out.
Yeah, absolutely. One that has made it into the courtroom, and I think especially given this wonderful headline, you can readily see how people can get behind this notion. Over at Ars Technica, Jackie Chang has written an article called Disney, Others Spy on Kids with Zombie Cookies. So this is about some unauthorized tracking technology using an ad widget from Clearspring Technologies that is alleged to be tracking children's activities around the web, not just on Clearspring partner sites. And a parent group is up in arms about this and has sued. And it really points out that, not only are we all walking around with our cell phones capable of monitoring each other, and of course, various municipalities and cameras are in our lives in various ways, but the companies that are out there trying to sell us things are very interested in our activities and even our children's activities online. And this one looks like it's going to challenge whether the activities in questions violated federal laws that are already in place. Evan, have you taken a look at this, and do you think this case is going to be rapidly resolved?
I bet it is, especially if Disney and others weren't fully aware of actually how this affiliate technology worked. Mm-hmm. It's sophisticated how the function of it, at least the description of it in the complaint here. And if indeed it's a fair characterization of how this is working, it's scary, because essentially what it amounts to is cookies that won't die. And so rather than calling them zombie cookies, we might call them, Nosferatu cookies in the sense of Dracula or of a vampire rather than a zombie. But, let's not get too technical in our macabre literature. So that's a real change in perspective here when you think of, if I'm going to delete my cookies, everything will be all right and you won't be able to track me, even if it's not just, because a big fear that I have, and I know that there's been some attention in the literature about this, is this notion of cookies persisting across sites so that the behavior of one user can be extrapolated from going from one site to the other, and even there can be leakage of personal information in that. This is even one step a little bit more distressing, if true, because even despite the efforts of the user to be proactive in keeping these things off of the machine and not permitting this tracking to occur, the information can be resurrected by going back into the flash. They call it the flash storage bin. I don't know how this particular technology works, but that's something that strikes me as peculiar to this, and something that's particularly troublesome, in addition to some of the other similar suits and concerns in this space.
Wendy, do you take any affirmative steps to keep yourself from being tracked around the web? And what do you think about this case?
Well, I do take a few different steps. Sometimes I browse using Tor, the anonymizing software with which I also work. The Tor project produces proxy software that hops your internet connection through several proxy nodes to disassociate the source of the communication with its content, so that a website can't track where you're coming from or identify you as the visitor there. And with that, we recommend some other browser plugins to keep your traffic unidentifiable, and to keep things like the browser plugins or JavaScript from identifying you while you browse. So the Tor button plugin and NoScript help you to keep from being identified. And I think all of that highlights that there are really lots of different ways that this technology is building fingerprints and other identifications of its users. The EFF's Panopticlick project noted that just the characteristics of users' browsers, the fonts they had installed and the plugins and browser sizes were enough to uniquely identify most of the browsers who came to visit. So there's a lot, even before you get to cookies that are specifically designed in Flash to hide better than the standard browser cookie and to resuscitate the browser cookie when it's deleted. That highlights some problems with our privacy law and policy. How do we give people adequate disclosure of what's being collected about them and what that means to them? And how do we help people to understand the meaning of that, even if the disclosures are accurate? How many people read the privacy policies of every website that they visit, understand what it means that information may be disclosed to affiliates to help with things such as sale of advertisements? And I think while a few of us may be able to change our browsing behavior, a few others may go to sites like EFF and Epic and ACLU to learn about some of the practices that they can take, or some of the companies to avoid because of bad practices. I think we also need more help from Federal Trade Commission and consumer protection law against this kind of tracking, or at least to help us understand what's happening. Now, there are some who argue that there's nothing wrong with behavioral advertising. It shows us ads that we like by following our preferences better. And if that's the case for some people, they should at least be doing it knowingly. And so I'm not sure about this lawsuit, I'm not sure whether the Computer Fraud and Abuse Act is the right way to go after tracking technologies, but it, I think, underscores the poverty of our privacy law, that we don't have better, more clearly defined causes of action.
Yeah, absolutely. And one of the only things we can do, thank you for mentioning Tor and describing how one can use it. I think people get a feel for it's a little bit complicated to go through that process. And it's likewise complicated to use the other utilities that are out there, not necessarily to anonymize you, but to identify, at least for you, give you the information that you need for how you're being tracked. And then you can block and remove cookies with them too. I have a couple of things to mention for our tip of the week. One is called Taco, and it's a plugin for Firefox. It is the targeted advertising cookie opt-out. And Doc Searles mentioned this on the VRM, Vendor Relationship Management list. And I installed it and have been using it, and it seems pretty worthwhile. There's one I haven't tried yet that I'll mention too, if folks want to kick the tires and let us know what they think of it. It's called Track Me Not, and it's out of NYU, trackmenot.org. So to be able to combat some of this kind of activity, you know, and how many of the parents do you think in this lawsuit actually had this kind of thing running on their computer? I would probably have to guess 0. So you can see how far it is between where we are and what can be done and what people out there are actually doing. David, any thoughts on this and advertising-related tracking?
I think the biggest issue here is Wendy articulated very well. It's all about disclosure and the way in which companies exercise requirements, should they have any, to disclose what they're doing with people's personally identifiable information. Right now, we don't really have any law out there which you could call the overarching privacy law. We have a couple of very industry-specific requirements. You know, things that you've probably heard of include the HIPAA stuff, which are requirements for handling medical data. There's the COPA stuff, of course, for handling children's data on the internet, and a few others related to financial institutions. But you know, I don't know that the requirements are laid out well for companies in order to set forth some sort of scheme by which they all disclose information in a way that's understandable to the average person that's going to visit the site. This morning I went over to Disney.com, since they were mentioned in the suit, and checked out their privacy policy, which is pages and pages long. I think I stopped reading about 10 minutes in, and is completely laden with legal jargon, essentially, defined terms, things that would require me to scroll back up and scroll back down in order to understand exactly what I was reading. And when you look at that, it's just, I don't know, I'm a lawyer, and I don't know how a non-lawyer would be able to get through that and understand exactly what was happening with their private information. And on top of that, I think that some of these instruments sort of give an avenue for companies to be ambiguous in them, and they might even have an interest in being ambiguous in a privacy policy statement, so that they can do other things that they didn't think of before when they originally wrote the privacy agreement. And it also makes it not very clear that sort of the third-party affiliations and selling it to otherwise authorized vendors and marketers of information that you previously authorized. Those types of things don't really tell you anything. It's just a bunch of defined terms that are a bit circular in argument. So I would like to see something that, some body of law, some movement by which there's a more universal way to do privacy policies online. You do see some sites out there that do a very good job about breaking it down into actual language that the average person can read. They take out the legal defined terms and you know, the paragraph numbering and the other things that are more typical of legal contracts between sophisticated parties, rather than just an average user that visits a website.
Right. Well, as if we didn't have enough with satellites tracking our every move, and one another with our phones and other recording devices, and advertisers trying to figure out what we're doing and who we are to sell us stuff, we also have courts who will unveil our anonymous identities if compelled to do so. And that is something that happened recently in Pittsburgh. Some anonymous bloggers were revealed, even despite the ACLU's intervention in the case, by an anonymous commenter. The issue was whether he was going to be able to remain anonymous, and the court, of course, in this case, said no. And there seems to be a lot of back and forth on this in the courts. Sometimes people's identities are protected. Sometimes ISPs who object and move to quash subpoenas are supported, and sometimes they're not. It seems to be kind of a Wild West situation out there. Evan, did you look at this one, and can we glean anything new from it?
The thing that struck me most about this one was, I think there were 3 different cases they were talking about in this article here. Mm-hmm. 2 of them involved topics.com, and another one involved a more local forum, Elizabethboro or something like that, .com. There was one of them where the petitioner, for lack of a better term, I don't know what the local term of art would be, but the one seeking to unmask the anonymous defendants was alleging something more than what you normally see on this. He was alleging that there was a real threat to himself and to his family, physical threats of violence. So I kind of would approach that with a different mindset than I would some of the other more garden variety typical cases like this that we see that usually involve defamation, where somebody gets their feelings hurt by someone speaking anonymously and wants to find out who they are and bring them to light for all of that. I looked at this one as a little bit different and could see a good, well-founded reason for courts to be more proactive and more solicitous to allegations of real threats of physical harm in unmasking an anonymous commenter. And this would all boil down to the same constitutional interest that's at stake here in the anonymous speaker. Clearly, there's no constitutional right to make physical threats against somebody, just like there's no constitutional right to defame somebody. But the inquiry should be more vigorous and perhaps more solicitous. And by that, I mean more likely to find in favor of unmasking an anonymous speaker if there are actual credible threats of physical violence going on here. That's the thing that rose to the surface for me on reading about this.
Wendy, do you agree with that touchstone for revealing an anonymous speaker online?
Well, I think by and large the courts have been converging on a standard that requires the complainant who wants an identity to show that there is a real case and to show some sort of prima facie evidence that what they would gather from the identity of the user would help them in prosecuting a real case. So it's not enough to wave your hands and say, somebody defamed me. You have to point out the facts that you claim are defamatory, or the statements of fact that you claim are false and hurt your reputation. And if you can say there is basic evidence that there's a case here, and giving me the person's identity is necessary to prosecuting the case against that person, that's the sort of thing that the law, I think, strikes the right balance. It's saying the internet isn't a completely different space where no law applies. If you take steps to conceal your identity in order to commit a tort, we will allow plaintiffs to go after that identity. If, on the other hand, they're just trying to get identities to harass or to go after a competitor, to unmask a political opponent, then they should be entitled to comment anonymously and not to have their identities revealed by force of law.
David, do you agree that we should look at this on a case-by-case basis and assess the facts and have a court examine the privacy interests on an individualized basis, or should we have a more sort of generalized rule about when it's okay to unmask an anonymous commenter. I mean, people complain about the anonymous nature of the web all the time, right? They say it's, easy to hide behind some anonymous coward designation and say things that you would never otherwise say. And the web gets kind of a bad rap because of this. Is this something that it's the court's job to intervene with, or should we just leave well enough alone?
Of course, no one knows that you're a dog on the internet, right? Mm-hmm. Well, I think that it has to be done on a case-by-case basis. In fact, I don't really see any other way it would strike that balance that Wendy was just talking about. And it's because anyone could file a suit and then issue a subpoena to an ISP to try to resolve either an IP address or an anonymous owner of a website who's posting either allegedly defamatory things or committing some other tort online. It has to come down to the merits of the case. And the standards that have been set by most states are not anything terribly onerous. You just need to show, for the most part, that you have some sort of colorable claim under the law, and that there's some merit to that claim as well. So because of that, it forces courts to go through and evaluate what the claim exactly is. They'll have a chance to look at some of the underlying facts that the plaintiff is setting forth. And in that time period, the anonymous person can also come forward and issue or file a motion to quash the subpoena and maintain his anonymity at the same time. So I don't really see any other way that we could have some sort of rule that would immediately unveil the anonymous nature of a speaker online and still keep the First Amendment, some of the tenets of the First Amendment intact.
Right. I wanted to go to you, David, with this because it was posted over at technicallylegal.org by your colleague, Ben Snitkoff, who was on our show last week, I believe, by the way.
Yep.
So Ben had a post there about a pretty interesting case, since we're on the subject of bloggers and how they sometimes are treated like second-class citizens, or the web in general is, because of sort of the free-flowing nature of the way information can come out there and the anonymous nature of some of that information. Here was a case where blogs got the same protection as newspapers in the way of what statute of limitations was going to apply. Can you tell us what happened there and why blogs and newspapers were decided to be treated the same by the court? And I'll preface this by saying, it seems to me as though you might actually more readily find something defamatory had been written about you if it happened in an online setting than in a print setting, because who knows if you're going to get a copy of that newspaper, if it's regional, whatever. But if you're out there actively monitoring mentions of your name or your brand or what have you, it's going to pop up if it's something that is being spidered and searched. So did that factor into this decision at all? And tell us about it.
I don't know that it actually made its way into the court's dicta at all in terms of the searchability of information. But this case was all about a lawyer, as a matter of fact, who had been litigating a case. And I believe what happened was there was a discovery order issued in the case, and a writer on a website felt that, however the attorney had handled the order that came down, it might have been improper. And so he wrote about it on the website. And this happened to be a website that publishes various types of articles, much like a blog. That's what the court eventually termed a mass media blog. This all happened about a year, or maybe it was even 2 years, before the attorney discovered it. The article was published, I think, in 2007, April 2007, and the attorney discovered the article in April 2009. And the attorney was based out of Pennsylvania. And in Pennsylvania, they have a statute of limitations of 1 year on defamation claims. The suit was eventually filed by the attorney in May of 2009, but this was some time after the statute of limitations had already run its course. So in those instances, generally, the case will be dismissed right out of court. There are a few exceptions, of course, to the statute of limitation rules, and one of which was a tolling provision, which they had in the state of Pennsylvania. And basically, it accounts for when a person becomes aware of some sort of legal injury that's happened to them, and it sort of resets the statute of limitations up until that point. But the court focused a lot on what exactly was what sort of protection was going to be afforded to the plaintiff in this case, in terms of whether or not he could actually make a claim. And it came down to the fact that this was a mass media publication on the internet, and the big limitation for tolling provisions is that if it's something that is easily discoverable online, or not just online, but easily discoverable whereby a person would know that they were injured or should have reason to know that they were injured, then the tolling provision does not apply. And that was the ultimate conclusion that the court reached in this case. And they said the tolling provision doesn't apply, the statute of limitations had already run, because the website was a lot like mass media. But they didn't really focus a whole lot of the discussion on what the different characteristics of the website as compared to mass media were. But at the same time, I think the big point to draw away from this is that the court was very willing to accept the fact that an online website can be much like a print media publication that's distributed around the country or locally around the town or within the city. And I think in the last 8 or 10 years, in terms of the legal protections afforded to bloggers, there just at times isn't a whole lot. There's a lot of questions in people's minds about whether blogging online or being some sort of online journalist while you're blogging is the same thing as writing at a newspaper. And there's a couple of statutes out there. Every state tends to have a shield law which protects journalists from being called in to testify on sources of information that they've obtained to write a story. Currently, there is, or at least there was last year, a bill that was on the table, a federal bill, that would provide some sort of federal shield law, but it importantly had carved out an exception for non-professional journalists, which seems to exclude the entire class of online bloggers. So those are more of the instances where we don't see some of the protections that are afforded to traditional journalists being afforded to bloggers online. And for that reason, I think it's a bit refreshing to see in this case that the court didn't even really spend any time saying, well, is this website really like a mass media publication? Or is it more like, you know, somebody's website where they just post their musings online or their day-to-day activities? I'm going to the store right now, or I'm going to go out and walk the dog. So that's where we're left, I think. And like I said, it's good to see courts are sort of becoming aware of the fact that people do read material online, and sometimes more often than they do in print media.
Lauren Gelman came along on my Facebook page and chimed in, thank you, Lauren, if you're listening, that she thought this was correctly decided, but one could better articulate some differences between the internet and traditional media publications that could better challenge the assumption that both should be treated the same. Wendy, what do you think of that take?
I was just going to look for Lauren's post while you asked me the question.
Oh,
so
she thought that maybe that this came out the right way, but that there were other differences between internet and traditional media publications that could better challenge the assumption that they should be treated the same. You agree with that?
Sure. I think that there are places where the technology makes a difference and places where it doesn't, I suppose. And in the context of statutes of limitations and tolling of statutes of limitations, I think finding that the similarity is greater than the difference, the reasons for ending a cause of action after a period of time because the evidence has dissipated and people should be entitled to certainty about actions in the past at some point, I think holds for publication across different media. I'm not immediately, in the course of speaking, coming to places where they should be treated differently, but I'm sure if given some time to think, I could offer up some.
Sure. Evan, what do you think about this reverse cyberspace exceptionalism, and is it a good thing here?
I think so. in this description of the case, I didn't read the case itself. I'm only relying on Ben's summary of it here. But he says that the court ruled that the discovery rule did not apply. And as we've addressed already, the discovery rule serves to toll the statute of limitations. The clock doesn't start ticking until the plaintiff knows or has reason to know of the injury that he or she has suffered. So in the online context, particularly for sophisticated plaintiffs who worry about their reputation online and who should be monitoring themselves, particularly businesses who may be subject to reviews on Yelp or a complaints board or ripoff report or whatever, the question of when they should have known about the injury that that he or she or it has suffered becomes particularly relevant. It would be hard for a plaintiff, a sophisticated business like a restaurant who is active and closely monitors what people say about it on the web, to say with a straight face that it didn't know of defamatory or otherwise tortious content about it online more than a year after that. And it would be even more implausible to say that they were suffering harm if they didn't hear about it more than a year later. So the searchability and the findability and the capacity for information about yourself to find you online would seem to greatly affect the analysis under this very precise part of the discovery rule, on namely the question of when you should have known about the injury. And that seems to be a huge distinction between online content and analog, non-online content.
All right. Well, this week for our resources of the week, I have a couple of links in the Delicious Talking Points. Again, that's at delicious.com/thisweekinlaw/74 to Wendy Seltzer's talk at Blog Her on mastering intellectual property, which was a nice general, here are the really hot button areas that you should know sort of presentation earlier this month, right, Wendy?
Yes, that's right.
To the Blog Her audience. So do you want to maybe share a couple of those tips with us now, and we'll let people go check out the links I just mentioned as the full resource of the week to get the whole overview?
Sure. Talking to the blogger crowd, it was a mix of sometimes you're trying to protect your own intellectual property, your own creative expression and branding. Sometimes you're trying to use material that others have created and to use it fairly. And so you might be both registering a trademark if you're blogging under a name that you want to keep for commercial activity. You might want to register copyrights if you have material that you suspect someone else will try to appropriate commercially. You might want to put a Creative Commons license on your work if you'd be happy to have them share the material and want just to give some guidance on under what terms and with what attribution you want it shared. And so we went through some of those, how to protect your material and some guidance on fair use for how to use others' trademarks in ways that are appropriate. You can use them to comment or to criticize or to parody, but not to sell your own product under that name. You can borrow somebody else's pieces of somebody else's copyrighted work in cases of transformative use, if you're taking an excerpt for commentary or criticism. But you can't, of course, take somebody's entire article, republish it under your name, and put up advertising to collect money unless you've gotten a clear permission to do that. So lots more of that, I hope, in the notes, and frequently asked questions on chillingeffects.org have some more of that material as well.
Wonderful. Thank you for that primer. I'm sure people will enjoy and find it useful. And thank you so much for coming on the show. Folks can find Wendy at wendy.seltzer.org/blog. That is the Legal Tags blog. And also W. Seltzer, Seltzer, on Twitter. So we really appreciate all your insights today, and you're taking the time to join us.
Thanks. Sorry about the poor quality video here, but I'm learning.
You look great. And yes, we appreciate your grappling with that issue for us too. Wendy's running Linux on her ordinary machine, and so the getting Skype to play nicely with Linux and all that was a good educational experience for us in getting ready for the show. So we really appreciate it.
And go Linux.
Yes, go Linux. And Evan, great to have you back on the show as usual. Really a fun discussion today. Thanks a lot.
Hey, well, thanks for having me. And Wendy, it was really nice to talk to you. Really enjoyed our conversation. And David, great to talk with you again.
So go find Evan on Twitter. He's Internet Cases there, and internetcases.com is his blog where you can find all kinds of good analysis of legal technology issues. And David O'Brien, thanks so much for joining us again.
Thanks for having me on. It's been great.
It's been really fun. Of course, go find David at the blog and podcast that reside at technicallylegal.org. And he is D_O'Brien with an E on Twitter. So, David, thanks so much. And hope to have you back again sometime soon.
I'll look forward to it.
Great. And with that, folks, court is adjourned here for episode 74 of This Week in Law. We'll see you next week, Friday at 11 o'clock Pacific. Take care.